in which the person is charged. And so this is, attempting to clarify where that person is supposed to actually be brought to. So we're going to be changing that to where the complaint subject to that particular bond was actually filed. And I'm guessing the proponents are going to get into why they think that that is a good change to be made.
Mr. Chair, may I ask one more? Assuming the same bondsperson bonded out in Finney County and Ford County, adjacent counties, where are they to be returned?
I'm sorry, I don't think I quite understand the question. So you're saying a person was, committed an offense, they're bonded out for that offense in what county?
With the same bonding company in Finney County and Ford County, adjacent counties. They busted bond in 2 adjacent counties where a person is charged and it's the same bonding company. Where is the person to be returned?
Well, and maybe the proponents can get into this a little bit more, but I think it's really about which bond, which offense it is that they're being brought back on. And so it needs to be in that jurisdiction. So if they're bonding out for multiple things from multiple counties, I think this is clarifying that if they're being brought in for that charge in Finney County, then they need to be brought to Finney County.
Both counties have warrants out with the same bonding company.
So if both counties have warrants out, and like I said, I think that the people who do this every day who are about to testify can probably clarify a little bit better than I do. So I'll let them address that.
Thank you, Natalie. Thank you, Mr. Chairman.
Any other questions? Not seeing any. We will move on to proponents. And let's see, via WebEx, we have Sheriff Easter joining us again today.
Good afternoon, legislators. I appreciate the opportunity to testify in front of you today. We are a proponent to House Bill 2076. Basically, I'll attempt to answer Mr. Wheeler's question as well. But basically what has happened, not with your more reputable bonding companies, if there's a warrant out of Sedgwick County and they pick them up in Ford County, they will bring them back to us. But we do have bonding companies that if Ford County puts out a warrant and they pick up the person in Osage County, they will book them into the Osage County jail instead of bringing them back to Ford County where they bond them out of, which then bears the burden of the cost of transportation, all of those type of issues, safety on the actual sheriff's office that had the warrant. And that's what we're trying to curtail. In reference to Representative Wheeler's question, currently we have that occur where there are 2 warrants from 2 separate counties. Say for me and Sumner County. If the warrant out of Sedgwick County is for robbery and the warrant for out of Sumner County is for traffic, they will bring them back to Sedgwick County because they have the highest charge. Now, when we book them, we also book them for the warrant out of Sumner County and put a hold. If by chance they pick them up in Sumner County and they got a traffic warrant, but they have the warrant for robbery out of here, they can book in Sumner County for that traffic warrant. Sumner County will put a hold on that particular inmate for Sedgwick County. So when the case is resolved or the judge has made a decision on the traffic case to either release them or hold them longer, either way, the hold's put on. We then will go down and pick up that particular inmate to answer to the warrant in Sedgwick County. With that said, we absolutely agree with the language. It did pass 39-0 with the Senate last year. Again, because of COVID, it didn't make it through the House. And we thank you for any consideration. I'll stand for any questions.
Sheriff, just to keep us moving today, I'm going to do all proponents, then questions, then, well, I'd say all opponents, but we don't have any opponents. So we're going to do the proponents, and then we'll come back to everybody. Next up, also on WebEx, we have Shane Rolfe.
Thank you, Mr. Chairman. Hopefully you guys can hear me okay.
We can.
My name is Shane Rolfe. I'm the Vice President or the Executive Vice President of the Kansas Bail Agents Association. We did participate in this bill last year, and there were some language tweaks that need to be made to solve a problem. Those changes have carried over into this current bill, so we're fine with that. Without getting too much into the weeds of what's an arrest and what's a surrender and those sorts of things, some of the questions that were raised, we do support the idea that if we pick someone up and we take them into custody, we should take them to the appropriate jail or the appropriate sheriff for the case that we have them on. We should not take advantage of what appears to be somewhat of a loophole in the language that would allow us to, pick someone up in Johnson County and then, surrender them there because we have a bond in Shawnee County, for instance, and then the Shawnee County sheriff is obligated to come pick them up. Now, one of the things to probably clarify on this is really going to apply more when the bonding company is apprehending someone or surrendering someone who does not have an active warrant for their arrest. Generally, law enforcement is going to take that person into custody if there's an active warrant, regardless of where they are, provided it's something that the charging jurisdiction is willing to come get them on. And then the bonding company statutorily could be obligated for the transportation costs of that under a separate statute from here. This creates a level of confusion with the local sheriff's office that if you're trying to surrender someone who does not have an active warrant, they have no idea what you're trying to surrender them on. And even if they acknowledge the fact that you have the appropriate paperwork for that, when they contact the original charging jurisdiction and there's no warrant, they're not going to know what's going on. So nobody's going to know anything about what's going on other than the bonding company. And it really is our responsibility as bondsmen to get them delivered to the appropriate location. If there are multiple bonds in multiple counties, there is a provision in 222807 that allows us to file what's referred to as a notice of incarceration to advise that other county that the person's in custody in another location, either in the state or anywhere in the United States, and see about getting a hold placed on them. So that's not going to be a particular problem, particularly if there's warrants. There could be issues where, if someone has two separate bonds and we think they're going to flee and we're trying to surrender them, but they haven't missed court on either one, we might have to do a little bit of extra heavy lifting to make sure those holds get in place. If we surrendered them in one county, we'd probably have to approach the other county's judge to try and get a warrant in to detain or place on that person and have them brought back. However, that's a pretty rare situation. I don't think that situation outweighs solving the confusion problem that local law enforcement would have on these when you try and surrender someone on a case that they have no knowledge about. But if there's any questions on this, I'm certainly open to taking those questions. We do support the language of the bill as it stands now.
Thank you. Committee, we have written proponent testimony from Jay Hall. Is there anyone else here or online that is a proponent? I don't see any, so we'll move to questions. Representative Carmichael.
Thank you, Mr. Chairman. Returning to Representative Wheeler's question, and this is for either of our conferees, it would seem to me that if I was a bonds person and I've bonded somebody out, say in Finney County on 85 and a 70, and I've also bonded that same person out in Sedgwick County on Ag Battery, that if I happen to grab a hold of them in Garden City, I can take them down and book them in on the presumably the warrant on 85 and a 70. I assume there'll be a hold or a detainer place for Sedgwick. But when the judge bonds them out on their own recognizance on the speeding charge because the jail is full of COVID, I think it means that Sheriff Easter has to come get them. Do I understand that correctly?
Yes, if there is an active warrant and a hold was in place, the local law enforcement, they're not simply going to turn that person back over to the bonding company to allow them to transport on that second bond. They're going to contact law enforcement in the jurisdiction that has the warrant to have them brought back. Another statute that I referenced before, 22-2807, does provide that the bonding company could be charged with those transportation costs of the sheriff having to go pick that person and bring them back.
Under what circumstances is the bonding company liable for the costs of the sheriff, not only for transportation, but his or her valuable time?
Well, I don't know how they calculate the valuable time aspect of that.
They
the sheriff
don't.
is actually executing a warrant.
They don't. So the way this bill is written, although it takes care of the problem of a bonding agent dropping somebody at the closest courthouse, this allows for the bonding agent to drop somebody at the closest courthouse where they happen to be holding the bond on somebody. And so the cost of bringing that person who's absconded back to Sedgwick County ends up resting on the taxpayers rather than the bonds person, except for whatever this circumstance is where they get 53 cents a mile. Is that the way it works?
Yes and no. The no is more that it would be then incumbent upon Sedgwick County to pursue that if they tried to pursue a motion for judgment on bond, and that's under KSA 22-2807, and the surety tried to raise the incarceration elsewhere as a defense, it is written into that statute that the surety can be held liable for the cost of having that person returned. It's not limited to 53 cents a mile. So if the sheriff wanted to calculate some additional time, I suppose there could be some argument over what's appropriate, but that is built into the other statute that would allow that. I don't know that it really impacts the language in this particular statute.
Well, I appreciate the explanation. You know more about it than I. It just seems to me that I don't know if we're really solving the complete problem here, but I guess this is better than what we've got now. Thank you, Mr. Chair.
Senator Owens.
Thank you, Mr. Chairman. I think that just maybe a point of clarification. I do have a little bit of expertise in this area. The statute specifically says for Representative Carmichael's information that upon the defendant's return, the surety may be ordered to pay the costs of that return. I can tell you that within our company, the sheriff simply sends me an invoice. They calculate in their time, their mileage, any other fees, the invoice gets paid. Or if they hire a transportation company, which is very common, then we're just invoiced for the cost of that, whatever that transportation company charged them. So as it relates specifically to this bill, though, I had a question maybe for Natalie. Do we have a definition of what the custodial officer of the court is? And the reason that I ask is it's implied that it is the sheriff of the county jail, or at least that's the implication. However, I have heard concern in the past that the custodial officer of the court is indeed the judge where that defendant needs to be returned to, and not actually the sheriff who operates the jail. Do we have any clarification on that in statute?
Mr. Chairman, I am not seeing just in the code of criminal procedure a definition of that, but let me do a little bit more research on that before I answer definitively.
Thank you very much. Thank you, Mr. Chairman.
Representative Wheeler.
Thank you, Mr. Chair. This is for either of our proponents, but Sheriff Easter testified about placing the person into custody in the county that had the most egregious charge. And that seems to be a matter of comedy between law enforcement and the bond people, because I don't see it anywhere in this statute of KSA 22-2809 in the event that there are 2 bond forfeitures in the state with bench warrants issued.
Sheriff, you're muted. There we go.
Sorry about that. Sir, what it's been my experience, what I've seen out of that is that because normally that is the higher bond that's been posted, the bondsmen want to ensure that that person is returned to that particular district because of the amount of money that was posted on that bond. So if you have somebody for ag battery, maybe it was a $50,000 bond. You have somebody on a traffic charge, it could have been a $2,000 bond. They're going to return them to where they could be potentially out the most money.
Thank you, sir. It's not in the statute, but I think the business acumen makes it important. Thank you, sir.
Any other questions for the proponents? Okay, I'll move on to neutral conferees. Is there anyone here today? What about opponents? Not seeing any of those either. Going to close the hearing on House Bill 2076 and move on to House Bill 2093. Open that up with an overview by Natalie.
Thank you, Mr. Chairman. House Bill 2093, sorry, you said 23 and not 2096, right?
Yes, 2093.
Okay, yeah, sorry. House Bill 2093 would change the penalties for the crime of fleeing or attempting to elude a police officer. It also adds provisions related to evidence and a prosecution for theft of a motor vehicle. So Section 1 amends KSA 815-68. That's the crime of fleeing or attempting to elude a police officer. Current law there in subsections B penalizes a driver of a motor vehicle who willfully fails or refuses to stop, or who otherwise flees or attempts to elude a pursuing police vehicle. Or a police bicycle or any type of police officer vehicle when given the visual or audible signal to bring that vehicle to a stop. And who commits certain other acts in the process while attempting to flee and elude that officer. So this bill would add operating a stolen motor vehicle to that list of acts. So if you're operating a stolen motor vehicle and you attempt to flee and elude the police officer, that's going to enhance your penalties. So violation of subsection B right now is a severity level 9 person felony. This bill would also add a new subsection C3 that requires the court to impose a fine of not less than $500 when the driver is operating a stolen motor vehicle during the commission of the offense. And then Section 2 amends KSA 215804, which is the statute related to theft that establishes certain prima facie evidence of intent to permanently deprive an owner of a possession. The bill amends subsection E to provide that in the prosecution for theft of a motor vehicle, fleeing or attempting to elude a police officer would then be prima facie evidence of the intent to deprive the owner of the motor vehicle use or benefit of that vehicle. And I can take any questions.
Representative Carmichael.
Thank you for your patience, Mr. Chairman. Ms. Scott, at least the first portion of this bill seems familiar. And I think the second two provisions, the $500 minimum fine and changing the presumption, may be new. Have we seen any or all of this before? And if so, where and how did it turn out?
Mr. Chairman, you have seen all of this before. It was contained in the provisions of House Bill 2448 from last biennium. You guys got that bill. You did make some changes to it. And those changes are reflected in this version. So this is the version as it left your committee last year. You passed it out of the House 98 to 25. And then it went over to the Senate. Similar fate. They had a hearing in early March, but it died in committee.
Thank you, Ms. Scott. It's just that my police chief has been so after me about this bill. I thought those bottom two provisions were brand new. Thank you.
Any other questions for Natalie? Okay, we'll move on to proponents, and first up is Ed Klump, and he is on WebEx.
Thank you, Mr. Chairman, committee members. I'm Ed Klump. I represent the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, and Kansas Peace Officers Association. We are back before you today with this bill, as Natalie explained. It went to the Senate and it was a casualty of COVID last year. So we wanted to start it back in the House since it passed here once. We thought it would be a good place to start it again. The bill, as Natalie explained, is exactly like it was when it passed the House last year. We did not make any amendments to it or revert it back to the original bill. I want to talk first about why we're here. Auto theft rates continue to rise in Kansas. They've been increasing every year since 2014, with the exception of the drop in 2019 that you see on the chart. The 2020 increase, we estimate is going to be about 10.3% from 2019. And that represents a 6.3% increase from 2018. And the 2020 numbers will be about 19.3% higher than the 10-year average. We came up with those 2020 numbers because the actual crime data is not available yet. Based on we were able to determine that there was a 10.3% increase in the number of NCIC entries in Kansas last year over 2019. And so that's where we came up with that. This is a statewide problem. In 2019, there was only 7 counties that didn't have an auto theft case. And so it affects almost every county in Kansas, large, small, rural, urban. In the U.S., they've been seeing a decline in auto thefts the last few years. You can see on the chart there, the U.S. reported thefts have been kind of all over the board the last 10 or 11 years. And Kansas, it's been kind of a steady increase over that entire time period. The per capita auto theft rate in Kansas is now about 38% higher than the U.S. per capita rate. In 2019, Kansas was the 17th highest number of the highest auto theft rate. There's a good chance in 2020 that's going to be worse with what we're seeing in the preliminary numbers. In 2019, Topeka Metropolitan Statistical Area was the 9th highest per capita rate in all of the MSAs in the U.S. From a dollar standpoint, Kansas suffered an estimated $78.9 million in loss in auto thefts in 2019. And those losses only include the motor vehicle and does not include other damages such as lost wages and things like that sometimes occur. In January 15th of this year, there was a news article in the Kansas City area. Overland Park saw a 42%, and they reported Overland Park saw a 42% increase in auto thefts in 2020 over 2019. On next, an 87% increase. Shawnee saw a 39% increase. I did some checking with some other cities around the state, and all of them were reporting increases, not to the levels that Kansas City area saw, but certainly in double digits in most jurisdictions. Stolen vehicles play a major role in attempt to elude cases, and that's why we married those two topics together in this bill, trying to address both sides of this problem. We have determined that a minimum of 1 out of every 5 attempt to elude cases in Kansas in 2019 involved a stolen automobile. We know that total is really substantially higher because of the large number of attempt to elude cases, pursuit cases, where we pull off the vehicle because of the risk involved before we ever identify the vehicle or the driver. I want you also to know that the public safety risk doesn't stop with the pursuits. Many of these vehicles are used in other criminal acts. They use them for disposable getaway cars. They use them to haul stolen property away because we get the video from a burglary and what we see is a stolen car being used, and they use it for drug sales and illegal drug trafficking. In 2018, one of the Metro Kansas City agencies looked at their data and was able to tell us that they could identify 30% of their stolen vehicles that were involved in other crimes during the first 10 months of 2018. So that's another aspect of the problem. I want to address the misdemeanor automobile theft issue. This was in the original bill last year, and this committee decided to strip that out, but I do want to address that again. In 2016, the legislature raised the floor on felony theft from $1,000 to $1,500, and it was a move to save prison beds. The consequences of that in respect to the auto thefts is that in 2017, 30.8% of the stolen motor vehicles were a misdemeanor case. And what struck us about that is you stop to think generally who is the owners of $1,500 or less automobiles, and it's people who can't really afford the loss. They probably don't have insurance to cover the theft loss, and often one vehicle families that then are put in other stresses because of the loss of the vehicle. And we felt that should be a felony, a level 10 felony. We still feel that way. If any of you are motivated to put that provision back in the bill, we would appreciate it. We didn't put it back in because we respected the decision the committee made last year. Also, a lot of the motor vehicle thefts where the vehicle is valued at over $1,500 get charged as a criminal deprivation of property because of the difficulty in proving the intent to permanently deprive the owner of the vehicle. And that leads to one of our amendments that's in this bill. So the three things, and Natalie explained them, that the bill does, and on page 1, line 34, it adds operating a stolen motor vehicle as a condition which makes the attempting to elude a felony case. On page 2, lines 6 to 8, it imposes a minimum fine of $500 when operating a stolen vehicle while committing a violation of attempt to elude. That was important to us because many of these cases, there's literally no penalty for the attempt to elude in these cases because it gets rolled into the other charges. And so many of the offenders see no reason not to attempt to elude, because if they get away, they get away. If they don't, they're not going to be in any worse trouble than they were anyway. And so we felt like that fine would send a message, at least, that it's not something you get away scot-free on. And then finally, in section 2, we're asking to amend 215804 by adding to the list of what constitutes prima facie evidence of the intent to permanently deprive when a person is driving a stolen motor vehicle and attempts to elude the law enforcement officers. Finally, we have 2 amendment requests we would like to talk to you about. These came up in discussions after the bill was introduced. And one of those was in discussions with the KHP, and they brought up a very good point. And the amendment would address a problem we have of a very high-risk maneuvers that we see frequently in these pursuits involving stolen vehicles. And that's when they cross the median on a divided highway and go into the oncoming traffic. And it's an effort to get us to stop the pursuit, which oftentimes is effective, and that's what happens. So what we're recommending is a amendment that would add a enhancement if they go on the wrong side of a divided highway into the oncoming traffic, or if they go into oncoming traffic on other roadways and cause a vehicle to take an evasive action, and then also if it causes a collision with another motorist. And then the second one came from a prosecutor, which is here today to testify, and it has to do with a problem with subsection A, where that is being interpreted that the multiple violations that add an enhancement only apply to the multiple violations of subsection A, so that if there is violations of subsection B, they don't count towards that enhancement, and it would attempt to fix that. And we've attached kind of drafts of how that could be fixed. Those drafts have not been through the reviser, although I gave them a fair warning that they were coming along with the testimony, so they'd be aware of it. But they haven't had the reviser look at those yet, put them in the proper format, just so you know. So if any of you would be willing to work with us on those amendments, we would greatly appreciate that. So this bill is trying to address a very dangerous situation for us, along with a very high dollar loss for the citizens of Kansas. And we would appreciate your support of the bill. Mr. Chairman, I'll stand for questions.
Ed, we will come back to questions. Next up, we have Major Dean.
That better? All right. I can start back over there. But again, thank you for having me here today. I'm Major Andy Dean with the Kansas Highway Patrol. And as Ed just stated, the KHP, we did submit written testimony in support of House Bill 2093, which we understand would make fleeing or attempting to elude a police officer while operating a stolen motor vehicle a severity level 9 person felony, and would impose a mandatory fine of at least $500 for that act. As stated in our written testimony to this committee, motor vehicle theft in Kansas is unfortunately becoming an increasingly common crime. Just 10 years ago, the KHP recovered 129 stolen vehicles, and in 2019, we recovered 471. So this represents an increase of 265% over a 10-year period. According to the Insurance Information Institute, the average dollar loss per theft of a motor vehicle is approximately $8,800. That was in 2019. Using these figures, in 2019, the KHP alone recovered an estimated $4.1 million in stolen motor vehicles, which is just a fraction of what Ed just covered for Kansas. Motor vehicle theft can be devastating to our Kansas citizens, as vehicles are oftentimes our first and second greatest financial asset. Motor vehicle theft commonly leads to vehicular pursuits, which is why I'm here to speak with you today. In 2010, the KHP reported having 11 instances where possession of a stolen motor vehicle was identified as a primary reason the pursuit was initiated. In 2020, approximately 70 of our 438 vehicle pursuits were identified as being primarily initiated because of the possession of a stolen motor vehicle. It is important to note that these only represent pursuits where a suspect was apprehended, and not pursuits where the suspect or the pursuit was terminated, rather, or other serious crimes were involved. Again, the KHP supports House Bill 2093, but we would also respectfully request the committee consider an additional amendment to KSA 8-1568, or a flee and elude statute. In recent years, our agency has observed dangerous maneuvers, as Ed also mentioned earlier, and these dangerous maneuvers are being carried out by fleeing suspects that pose serious safety issues to the motoring public. The most hazardous of these actions occur when suspects intentionally drive left of center, oftentimes on our divided highways, coming into oncoming traffic to evade capture or arrest, or when suspects enter an intersection in such a way that other motorists, bicyclists, and pedestrians on the roadway are forced to make evasive maneuvers. All too often, these intentional acts result in crashes that lead to serious injuries or even death. The amendment we are proposing would create a section in KSA 8-1568 that addresses suspects who willfully drive the wrong way into an opposing lane of travel on a divided highway, as defined in KSA 8-1414, who willfully departs the appropriate lane of travel into an opposing lane of travel on any roadway, causing an evasive maneuver by any other motorist, bicyclist, or pedestrian, willfully drives through an intersection, causing an evasive maneuver by any other motorist, bicyclist, or pedestrian, or causes a collision involving any other motorist, bicycle, or pedestrian. The amendment we are proposing would also enhance the penalty in those cases to a severity level 7 person felony. I'm sure that most of us, if not all of us in this room, have known someone who has been seriously injured or killed in a car crash. And suspects who intentionally drive left of center and into oncoming traffic to evade capture or arrest are steering essentially a 4,000-pound bullet in the direction of the motoring public and potentially our families, and they need to know that we are serious about this issue. A KHP trooper recently made an arrest following a pursuit, and during the interview of that suspect, the suspect explained how they knew an individual in Colorado that they had spoken with who had information that, or at least advice that when you run from the police, you go across the lanes into opposing traffic, simply knowing that the law enforcement are likely going to terminate that pursuit. And so we feel that this is the sentiment that's currently out there, and it's a serious issue for us. As an agency, it is our goal to vigorously pursue, apprehend, and prosecute those who utilize Kansas highways for criminal activity. And again, House Bill 2093 would assist our agency in carrying out our mission and goals and deter and penalize those who choose to victimize and jeopardize our citizens by committing these crimes. We know that life safety is extremely important to all of us, and we thank you for the opportunity, and I'm here to stand for questions.
Very good. We will get back to you on questions. Greg Smith on WebEx.
Thank you, Mr. Chairman. The Johnson County Sheriff's Office appreciates the opportunity to provide testimony on this bill. Much of the same statistics that you heard from the first two proponents we have in our testimony as well. I do have the information from Johnson County, at least since 2015, and our stolen car rates have gone sky high. 2015 and 2016, we had one car each year that was stolen within the Johnson County Sheriff's Office jurisdiction, not counting all the cities that are within Johnson County. In 2018, we went up to 13 stolen cars, and then in 2019, we saw a 200% jump in stolen cars and went up to 39. And then this last year, near as I can tell from going through our records, we had 43 stolen cars, which is a 10% increase, which is about what Ed was talking about in his testimony. A lot of these thefts that we see, the cars are stolen so that that person can commit another crime. They're tied in with shootings, with robberies, homicides, drug deals. The cars aren't necessarily stolen to sell the car, to part the car out, but to be used in some other type of crime to hopefully try to conceal the identity of the person that's committing those crimes. We are extremely happy with the bill as it came out of committee last year with the 3 amendments that are in this bill. We do support the amendments that were offered, proposed amendments that are offered by Ed in his testimony and the Highway Patrol. We're particularly concerned about the thefts of a motor vehicle that are under $1,500. It's our experience that most of those people are lower income families. That's probably the only car they have, and they're not in a position to be able to replace that car with any immediate resources that are available to them. They're usually not insured for theft and those kind of things. So it's a very devastating thing that happens to those families. And we look at this amendment of raising that to a felony offense as being a victim-friendly type amendment, and we would support that should the committee choose to act on that. And I'll be happy to stand for questions at the appropriate time, Mr. Chairman.
Next, we have Todd Thompson.
Thank you, Chairman. Thank you, committee. I believe most of the statements that have been said already kind of illustrate the issue that prosecutors have been seeing. If you don't know me, I am the County Attorney of Leavenworth, past president of the Kansas County and District Attorneys Association, as well as the legislative chair. Again, the issues that we do see most commonly with fleet and looting vehicles are those that have been stolen, and it has constantly caused a issue for law enforcement that I'm aware of. Again, this is still something that would have to be prosecuted after the fact, but this step would be very beneficial for our law enforcement. Further, we did, as prosecutors did, have in my office an amendment, just a technical fix. there's a little bit of you can increase the burden to a felony for a subsequent flee and elude, but it only makes it if it was a previous misdemeanor. And we want to make sure the language is as clear as possible that anyone who had a prior flee and elude, whether it's a felony or misdemeanor, would be seen as a subsequent one would have a higher penalty regardless of what that punishment would be. And further, and lastly, is the Highway Patrol's proposal. We also very much agree that when coming into ongoing traffic, this causes even a greater concern, and we would like to see a penalty or a harsher punishment regards to that. I can tell you we have had multiple cases where injuries, much less death, has occurred when incidents were going into oncoming lanes and hitting people. So we would like to be able to have that beneficial. I stand for questions when time's appropriate.
Thank you, sir. Committee, we have written proponent testimony from the National Insurance Crime Bureau. Is there anyone else in person or online that is a proponent? Not seeing any. We'll begin with questions. Representative Heiberger.
Thank you, Mr. Chair. I have a question for Ed Klump.
Yes, sir.
Ed, as someone whose car may well likely fall in that $1,000 to $1,500 value range, I was wondering if you could tell me what percentage, you said about 30-some% of the cars stolen fall under $1,500. Do you know how many of those fall within the $1,000 to $1,500 range?
I do not know that. I got my data on that 38% under $1,500 from the KBI. I think I could probably get that. I'm not sure how quickly they can get that data for me, but I would suspect a big chunk of them are, but I just don't have the data to say for sure. I mean, a car less than $1,000 today is probably rare.
I know.
It gets Boog here every day. I see him get in and out. Representative Carmichael, do you have a question? Or that's just a thumbs up? Just a thumbs up?
I do, as a matter of fact,
Okay.
but I've had the pleasure of riding in Representative Heiberger's present car, and it's worth no more than the car he had before, but at any rate. I do have a question for Major Dean, as well as perhaps Mr. Thompson, and it has to do with this crossing the center line, or crossing the median, actually, flee and eludes. Major Dean, you told us one anecdotal report that a trooper was told by somebody from Colorado that the word was the way to get away from the law is to cross the median. And so you're advocating for this change in the law based just on this anecdotal report of what some speeder told us. I'm confused. And then we can turn to Mr. Thompson and perhaps also Mr. Pope. Major Dean, is there more to it than just this one story that a trooper heard somewhere?
No, that's just information that was passed on to me. And like I said, it's just the sentiment that we see there, with the increase of suspects crossing over into the other opposing lanes, that increase kind of supports that sentiment. So.
Yeah, I'm just trying to look to quantify the extent of the problem. I can recognize it's dangerous. I can think of a lot of things that are really dangerous involving chases and flees and elude. And I'm trying to figure out how often this happens. Mr. Thompson, you said it happens in your county there in Leavenworth. How frequently?
I would have to use an availability heuristic because I don't have a statistic on that, but I would say more likely than not, I would say it's very frequent that cars will do almost anything to elude, much less going over the lines. I don't know many cars that don't do that when they're trying to flee elude. And it's become a more commonplace, and law enforcement could probably address this more than I can, that terminating pursuits is the standard practice for safety reasons, not only the safety of the public, but the safety of the officer. And so, doing action, I think that's becoming kind of a norm for the fleet eluders, knowing this, that they're if they can actually do it, the law enforcement is going to break contact. So I do believe it is a serious issue.
Mr. Thompson, not to press the issue too hard, but I find it very hard to believe that the majority of the chases in Kansas involve the suspect crossing a median. Are you saying in your county the majority of the chases, the flee and eludes, involve somebody crossing the median into the oncoming lane of traffic? That's not consistent with my experience. Is that the way it is in your county?
I mean, I guess, Mr. Carmichael, what do you consider crossing the lane? I mean, anytime you go over the lane into the other ongoing traffic, that I would consider that going into ongoing traffic.
Not what I'm talking about. I'm talking about the amendment that you're offering to the bill.
Correct.
The conduct that's described there, which I understood was crossing the median into the oncoming lane of traffic. Instead, are you saying anytime somebody crosses the center line in the course of a chase, you want it to be a felony?
Well, I guess then I'm misunderstanding what you're considering going on to oncoming traffic, because anything that's going on to the other side of the lane would be not just a 4-lane road, but an actual into the oncoming traffic is what I'm referring to.
So then, but we understand Leavenworth County Attorney wants to make it a felony anytime in a chase that the suspect crosses the center line because they're entering the oncoming lane of traffic. You want all those people to be felons. Is that your position?
Yeah, I have no problem saying that's my position. I think flee and eludes are some of the most dangerous, not only for the public, but also for the law enforcement. So I have no qualms that anytime someone tries to elude a person that puts other people in harm, that it should be looked at as a felony. So I will say
I understand. I understand that's real easy for the elected county attorney to say because he doesn't have to fund the state prison system. Mr. Klump, maybe you could give us some more information about how frequent it is. And I thought we were talking about crossing a median, but now Mr. Thompson says no, anytime it's across the center line. Can you give us an idea as to how frequently this problem happens?
I'll attempt to address that, but first let me clarify what our proposed amendment. The last page of my testimony, I have that draft of what we intend, and it would apply in not only cases where the vehicle goes across a median into oncoming traffic, but it's not just when they go left of center either. What we propose where it's not a divided highway is that it raises the level when it causes another motorist to make an evasive maneuver. So it's not just crossing the center line, but if they cross the center line with those other oncoming cars present, and they have to make an evasive maneuver. And then it also would cover if they're involved in a collision with another motorist, or if they're drive through an intersection causing a motorist to make an evasive maneuver. And we'd certainly be open to discussion on all of those elements if somebody would like to pursue this amendment. Back to the frequency of this, I have information that this week in Sedgwick County, the sheriff's office had 3 pursuits, and every one of those went left of the median on Kellogg. I know that about 3 years ago, we had a case on North 75, which is a divided highway, where a person went across the median and struck a car driven by one of the Topeka police off-duty officers and occupied by his wife, and the officer was killed, and the wife was critically injured in that accident. And you know, I don't have numbers to say what that percentage is, but we see those reports quite frequently where that is occurring.
I appreciate the information, Chief. I'm going to have to think pretty hard about this because it sounds like really what we're doing is we're turning every chase into a felony case based on the definitions that I've heard here, and certainly based upon what Mr. Thompson wants. Yeah. That doesn't seem right to me.
If I could add to that, if you look at, I don't have the bill here, but if you look at the bill on the provision on page 1, line 34, you see conditions in which the pursuit becomes a felony. And one of those is multiple moving violations. Very few of these pursuits that rise to that level are not felony pursuits. However, what the amendment proposes is raising the level of that severity in these cases where they are adding an extreme danger to other motorists.
Well, I'll just have to take a more careful look at the bill. Thank you very much, folks.
I would expect nothing less from you, Representative Carmichael.
I appreciate your confidence.
Any other questions for the proponents? Yes, Representative Schreiber.
Thank you, Mr. Chairman. And this is really more curiosity, and I appreciate all the information. This has been, for me, interesting conversation. But with these changes and potential amendments, have they been used in other states where to possibly drive down thefts, auto thefts, or pursuits or something, things like that?
I wish I had more information to give. I did not do a lot of the research on this. I don't know if Ed, if he would have that information or not. No,
Somehow I became muted.
Thank you, Mr. Chairman.
I did not do that research, but I don't think I'd be able to ascertain, even if I did, when those changes would have been made and what the effects were.
Any other questions? Okay, thanks to all of the proponents. I don't show any neutral or opponent testimony. Is there anyone online or in person that's a neutral or an opponent? Do not see any. We'll close the hearing on House Bill 2093, move on to House Bill 2096. Open that hearing with an overview by Natalie.
Thank you, Mr. Chairman. House Bill 2096 would authorize certain employees, Department of Corrections employees, local correctional or detention officers, judicial branch employees, municipal court employees, and certain administrative hearing officers from having their identifying information with regards to their home address or their home ownership. It would allow them to restrict that from public access on websites. So the bill amends KSA 45-221. That's a statute in the Open Records Act that describes the records that a public agency is not required to disclose. And so this bill makes some technical changes throughout that you'll see, but the big change is to subsection A51, which is starts on page 7. So current law allows a law enforcement officer, a parole officer, probation officer, a court services officer, community corrections officer, a federal judge, justice of the Supreme Court, judge of the Court of Appeals, district court judge, district magistrate judge, municipal judge, the U.S. attorney for Kansas, assistant U.S. attorney, special assistant U.S. attorney, the attorney general, assistants, special assistants, county attorneys, assistants and specials to them, to district attorneys, city attorneys. All of those folks are currently able to request that their identifying information be restricted from public access and records on the public agency's public website that identifies their home address and their home ownership. This bill would authorize a few more types of employees to have that ability to restrict that information from the web. Department of Corrections employees, a local correctional officer, a local detention officer, an employee of the judicial branch, a presiding officer who conducts hearings pursuant to the Kansas Administrative Procedures Act, an administrative law judge employed by the Office of Administrative Hearings, a member of the State Board of Tax Appeals, an administrative law judge who conducts hearings pursuant to the Workers' Compensation Act, and a member of the Workers' Compensation Appeals Board, or an employee of a municipal court to make that similar request that's already available to those other employees. Current law regarding that request process and the timing of the request is maintained. The public agency is required to restrict that person's identifying information within 10 business days after receiving that request, and the restriction expires after 5 years. The person can then file a new request for restriction at any time. And I can take any questions.
Representative Carmichael.
Thank you, Mr. Chairman. First, I suppose I should inform the committee that on occasions I've served as special administrative law judge for the Department of Labor. Don't have any pending cases assigned to me now. I'm in the legislature, but to the extent that that constitutes any bias or interest, I want folks to know. Now, my question for Ms. Scott is the usual. I think we've seen this before. If so, when, where, what was its fate?
Mr. Chairman, you have seen a bill similar to this before. Last year, Senate Bill 331. That bill, though, included the Department of Corrections employees, the local correction or detention officers, the judicial branch employees, and the municipal court employees. It did not include the administrative law judges, the Board of Tax Appeals, the judicial branch employees. So that bill came over to you from the Senate. They voted it out 40-0. You guys did have a hearing on March 9th, and then it died in your committee.
Thank you.
Representative Keither.
Thank you, Mr. Chairman. Natalie, with the language in here, would this be considered what is known as Daniel's Law? Protection of judges' information.
Mr. Chairman, I am not familiar with that term. I would have to look it up. I've never heard it referred to as that, but it very well could be. I can look into that and see. I will say the judges
do that, and I'm thinking this covers it.
Okay. Yeah, and the judges are actually already covered by this in current law. We're not making any changes to the protection of judges, district court magistrate judges, just administrative law judges.
Yeah, there we go. We see you again, Representative Keither.
I couldn't hear most of it.
Gonna try again, Natalie.
Okay, we'll get there.
Yeah. Okay. So can you hear me now?
Yeah, I can.
Okay, perfect. So I'm not sure if this is like colloquially referred to as that or not. I can look into that, but the law remains the same as to judges. Judges are already included in this. So they already are able to request that information be restricted. We're just adding a few groups of people, including administrative law judges, but district judges, magistrate judges are already covered.
Okay, gotcha. All right, thank you very much.
Other questions for Natalie? Representative Wheeler.
Thank you, Mr. Chair. And Natalie, I seem to recall back in the years that I was county attorney of Finney that there was a bill, and it may be this 45-221 or where it gave law enforcement and other people, I think county attorneys, the ability to shelter their identifying information from public places. And people were rushing to do that until they found a downside to it, that when they went to sell their house, nobody could locate any document with their name on it. And I noticed that in this bill, it it expires after 5 years, at which time the person has to renew. Other than that, what measure can be taken to remove it to protect from these other ancillary problems that arise from hiding from the public?
Mr. Chairman, I'm not sure that there would be. I'm not seeing anything specifically related to revoking that request, just that it expires within the 5 years. So I'll have to look into whether currently they're able to have that expire sooner or revoke their request to have that taken, to have that information sealed. But yeah, I'm not sure at this time.
Thank you, Natalie. Thank you, Mr. Chair.
Any other questions for Natalie? Okay, we'll move on to proponents. First up is Joe Molina. I can't.
Better?
There we go.
There we go.
The mask's on. I don't know if the mic's on or not. Just.
Joe Molina from the Kansas Bar Association. I appreciate the time. Chairman Patton, members of the committee. We actually requested this bill after we heard from the Office of Administrative Hearings. They had 3 instances in the last 12 months where one of their ALJs, which is what they're actually formally called, they're appointed as ALJs, were threatened at hearings. And that threats were significant enough that they actually filed police reports with the Capitol Police and investigations were done. In addition to being threatened at the hearings, on 3 of these instances, these individuals then try to contact the ALJs through Facebook. And this forced, or properly so, the Office of Administrative Hearings to start taking precautions. They renovated their entire building. It is now more secure. The public and staff are now separated. They do not share any common space. They have key card protections. They have swipe protections. And they have other measures taken into account to protect their staff while at the office. And they heard about this bill and they're looking down, they understood that they were not protected. And when you look at the threats that happened and the ones that they're familiar with, they went from threats in person to threats online at Facebook. It is 2 steps, a 9-iron basically, to getting to the county appraiser's office, which is what I think of when I'm thinking about public access where you can find a home address. While I was sitting in the back, I actually looked up Shawnee County appraiser's office, and in about 30 seconds, I could find my own house. There are actually 9 Molinas in Topeka, which is odd. And so that's why we actually brought it up. And I really have to thank Natalie because we worked through, we were just going to add administrative law judges for the Office of Administrative Hearings. But there is a loophole there. There's a group of individuals who actually have the same safety concerns when you talk about judges, when you talk about police officers and all those types of things. And ALJs were not protected, so we wanted to expand that to include tax appeal, the Board of Tax Appeal, workers' comp, because in most of these instances, when your ALJ makes a ruling, 50% of the people in that room are not going to be happy. And we found out that in 3 very specific instances, this isn't a proactive thing where we want to protect people. We've already had threats, right? This is a reactive thing. We need to close the loophole. I understand that there's other groups that want in on this. We have no problem with that. We try to cast a pretty broad net with Natalie and make sure we got all. But if we didn't, and these people fit these types of parameters and they would like this type of protection from having their information out there, we don't see that as a bad thing. We actually would support those types of issues. I talked to Representative Wheeler earlier. I actually made a couple phone calls when I stepped out into the hall. There is a process for title examiners to request from the homeowner an affidavit, allowing that information to be released, and then you can proceed down with some title insurance and title examinations. I'm not sure how often that is actually done. And there is another issue where people aren't pulled off after 5 years. And so that is more of an enforcement thing than anything else. But as the law is written, we support it. If you have any questions, I'm happy to stand for questions.
Okay, thank you. Next, we have Randy Bowman, and Randy's online.
Yeah, hopefully things are coming back here. Thank you, Mr. Chairman. Hope
See you. There we
everybody can hear
go.
me okay.
Perfect.
Good. Thank you, Mr. Chairman, members of the committee, for the opportunity for the Kansas Department of Corrections to weigh in on this. We do support this measure again this year. I appreciate that others have brought it back before your attention. You have my written testimony, and I would just augment that by just kind of giving you a little context to why the words in the bill in line 31 are purposeful and important to us when it says an employee of the Department of Corrections. Some of our employees, like parole officers, have had this historically, but we have employees who make decisions and interact with our residents or our parolees in the course of their duties that we just felt the more inclusive term was appropriate. So whether that is a uniformed officer in a correctional facility, whether that's a corrections counselor, whether that is a maintenance staff, because our maintenance staff work on crews with residents. And if something goes south and they don't like that decision, they might target that employee's family and residents. So we support this, appreciate others bringing it back before your attention this year, and hope you will leave the language related to Department of Corrections as broad as it is proposed as any employee of the department. And I'll stand for questions at the appropriate time.
Very good. Thank you. Next, we have Amanda Stanley. Weather was so nice, she decided to come over in person instead of WebEx.
Keep watching too many hearings where things freeze. Thank you, Chairman Patton and the committee, for allowing me to come back before this committee today. I'm here today to testify in support of the inclusion of municipal court employees, as well as the continued inclusion of city attorneys, municipal court judges. We live in a divided world where social media just keeps amplifying things, and when it is so easy to access addresses, it does add additional safety concerns. In response to Representative Keither's question, I do have a quote from Judge Salas in my testimony, and that's what Daniel's law is about. It's the killing of her son. She was a federal court judge. But she made the comment after the shooting of her son and her husband that we know our job requires us to make tough calls, and sometimes those tough calls can leave people angry and upset. But what we cannot accept is that we're forced to live in fear for our lives because personal information like our home addresses can be easily obtained by anyone seeking to do us or our family harms. And she called on state legislatures to add these kind of protections. We already have protections for our municipal court judges in Kansas, but we do think it's important to continue to expand that as necessary and include the municipal court judges, and we appreciate your attention to this issue.
Good, thank you. Committee, you have written proponent testimony from Heather Cessna and Christina Silva. Is there anyone else online or in person who is a proponent? What about a neutral conferee? Any opponents? Okay, we'll close the hearing. Yes. Question.
Sorry, I was scheduled to. This is Sheriff Easter. As a proponent.
Oh, you're here as sure. Fire away. We're ready for you.
I'll be, very quick on this. As it was stated earlier, it's passed out of the Senate 40-0. From the KSA standpoint, it is simply for the Department of Corrections, local correction officers, and local detention deputies or officers as well, is what I'm testifying to. As most of you know, corrections people get threatened on a weekly basis. A lot of times they are seen in the public by former inmates. Comments are made, threats are made. These are predominantly, other than one jurisdiction that I'm aware of, are unarmed personnel that work in our jail system. And I think it's imperative that they receive the same type of treatment as the folks that are armed. Detention personnel are with the inmates 8 hours a day, not just from the time of contact to the arrest to the booking, which sometimes can be an hour, sometimes can be less, sometimes can be more. So I think it's very important that we also protect those doing the job of protecting the community from inmates that have committed violent acts or other acts upon victims in our state. Thank you. I'll stand for any questions.
Thank you. And yeah, I was flying right by questions, but Representative Carmichael's raised his hand, so we'll start with him.
Thank you, Mr. Chairman. Sheriff Easter, if my memory is correct, there have actually been detention employees of your office who've been the victims of assaults and the like outside the workplace. Is my memory correct in that regard?
Yes, we've had some assaults of some of our deputies outside the workplace.
And that certainly reaffirms to me the need to try to provide those folks with some protection in their private lives. But the other side of it is, unfortunately, there's quite a bit of turnover in the detention officers at the sheriff's office, and despite your best efforts to hire only the best, the most brightest, and the most qualified, unfortunately, some bad eggs apparently slip through every now and then, and they end up being charged. I think the way, though, this law is going to work is once you qualify, even if you only work for Sheriff Easter for 3 weeks before he has to fire you, it looks to me like you get a 5-year sealing of your records. Is that your understanding too, Sheriff? Or we could ask.
Yeah, and
I think that's the way that's going to work. I think.
Yes, that's the way I understand it. And it's not necessarily, yes, we do fire some folks, but we do have a lot of turnover because not a lot of people like this particular profession. And so
because they can make more money working for another agency or driving a truck.
True.
I'm sorry.
That's unfortunately true. And so that's a very good question of how those folks then should be removed because they no longer work in that profession. I don't know, but that is a good question. I think that's something that we need to explore.
Now, I'll also grant you, though, that if you spend 20 years in the profession and you retire, that doesn't mean there won't be people getting out who'd like to come looking for you, too. So I can understand. I guess my difficulty is in those sad cases where the residence becomes the county jail of people who used to work there or becomes Department of Corrections. I just wonder if we ought to conceal their personal information for 5 years. More a rhetorical question. I don't expect really an answer, just something to think about. Thank you.
Okay, sir.
Other questions, committee? Okay, now we will close the hearing on House Bill 2096. Committee, just a couple of things. First of all, I'm going to go over the list of bills that we hope to be able to work again tomorrow. 2049, 2050, 2071, 2079, 2080, and 2082. And now that we're on 2082, I'm going to call on Natalie to provide us a little bit of information about House Bill 2082.
Thank you, Mr. Chairman. Committee, I made a pretty egregious error in my bill brief on House Bill 2082. So similar to Representative Carmichael's line of questioning that he asked me about all these bills, this is based on a bill that was introduced last year, but there was another Crime Victims Compensation Board bill introduced last year, House Bill 2305, and I actually briefed you on the contents of that bill and not the bill that's before you now. So I have corrected my written bill brief and I will get that to Kathy and she can distribute it. But I am going to re-brief that bill and tell you what the contents are. So that way, when you guys are reviewing it, you can actually have the right content in front of you. And many thanks to Bob over in research who pointed out this pretty big error on my part while he was working on his subject. So House Bill 2082 still does make changes to the Crime Victims Compensation Board. Section 1 still does amend KSA 74-7301 to define victim. So we're adding that a person who witnesses a violent crime when they're 16 years of age or younger at the time the crime was committed, we're still adding those folks into the definition of a victim for purposes of awarding compensation. Section 2 of the bill amends 74-7305, and all the changes we're making there are removing the list of sexual crimes that are listed out there and replacing it with the term sexually violent crime as defined in KSA 22-37-17. So that adds some of those other types of sexually violent crimes that are listed in that definition. It also does allow the board to award compensation for mental health counseling for victims of those sexually violent crimes after that 2-year period, if the board finds there was good cause for the failure to file within that specified 2-year period. But the portions about the online application and the 72 hours reporting to law enforcement or seeking mental health treatment. Those are not in this bill. So I can take any questions that any of you have on that.
Any questions for Natalie? So I'm going to leave that on the list of bills to work tomorrow. If you all get back and you read this and you've got questions and you're not comfortable moving forward, then we certainly won't move forward. So we'll talk about it tomorrow, and when we get there, decide what to do. We obviously had proponents who testified in favor of the bill that they thought it was, and Natalie just caught us not paying close enough attention to her brief to realize that she was describing one that was not exactly the one that we were considering. So shame on us. Okay, committee, one final thing, and have a couple of you have had questions today about this item on the agenda. It says discussion special interim committee for the Kansas Emergency Management Act. We're not discussing that today. It's simply on here because Kathy is going to email you the interim committee report that we issued from this fall. It's actually, for the public's sake, it's on the Kansas Legislative Research Department's website, along with all of the other committee reports from the fall. I just wanted to make sure to get that in front of you early to make sure everyone's going through that and looking at what that report included, because at some point in the near future, I don't know when yet, but we're going to start talking a little bit more about the Emergency Management Act, and I didn't want to spring that report on you at the last second and you've not had any time to review it. So that's why it's there, so we can acknowledge the public knows that we have it and you're going to get it. That's all I have for today, committee. We've got one bill hearing tomorrow, and then we'll see how many of these we can work through before we're done for the week. So thank you all. We will see you all tomorrow. Have a good evening. We're adjourned.